So who's in the room? We've got some already participants who have told us where they're from and their names. So 26 attendees in the room. Welcome again. My name is Jo Aschenbrenner. I'm a German qualified lawyer and mediator, and I'm partner and member of encode.org with several roles within encode relating to building a legal community and doing legal work within encode. With me today, I will be your facilitator today, and with me is Tom Thomason from encode, who will briefly present himself, and he will be your speaker today. So Tom, why don't you just say a few words?
Yeah, thanks, Jo. So Jo is my legal muscle. So I am Tom Thomason, an entrepreneur by background. Some of you probably know me from my Holacracy 1 days. Still very much connected to Holacracy 1 and very much interested in furthering its purpose in the world. But you'll hear a little bit more about my backstory and why encode.org exists. Ever pursuing my entrepreneurial proclivities, I saw a need to launch a new organization. And so that's kind of what we're going to dig into today. We're going to assume that folks have a general knowledge of self-organization. And as Jo said, this was designed to be kind of a deeper dive on the legal side. Over the last year and a half, I've had the opportunity of going around the world and doing one-day workshops, kind of presenting the general overview, more experiential of what encode is offering now. But this will be more narrow in focus and obviously a much shorter time period. So I'm going to take you through a little bit of the backstory and then as quickly as we can get into the actual meat of the matter, which is the legal agreements. So I see a lot of familiar faces, or names anyway, from all over the world. Again, I'm an entrepreneur by background. Holacracy 1 was my fifth startup in 30-some years. Encode.org is now my sixth. Encode.org was founded differently. It was a founderless organization with no classic owners in the conventional sense of that term. So I'm an entrepreneur, always looking for better ways, new ways, cutting-edge ways of relating to our work and our investments and earning a living. And so today we're going to dig into that a little bit more. So some of you know me from Holacracy 1 days, and some of you are brand new. So welcome. Looking forward to exploring with you.
Okay, thanks. Ra from encode.org just wrote in the chat, so if you want to see the presentation as big as possible, so follow his instructions, please, and minimize the videos and enlarge the presentation as much as you can by hitting the bar. Thanks, Ra. As regards content and structure of our webinar for today, we will start with a presentation by Tom, as he just said. And we would like to have at least 20 minutes, 30 minutes for a discussion afterwards. A discussion meaning, however, that you put your comments and questions in the chat, and then I will read them out, and then we will answer your questions. You will not be able to use a micro and talk, but you will have to use the chat. And should there be urgent questions or remarks during the presentation, please also use the chat. Okay, so we will start with Tom's presentation, followed by a hopefully very interactive and lively and critical and discussion with all of you. Thanks. So Tom, please.
Yeah, thank you, Jo. So everybody should be seeing a screen share now of kind of our just PowerPoint or Google slide share here. All about upgrading the legal structures. So before we dig right into what that looks like, a little bit of background. So we're playing in a pretty broad field here. Lots of folks are exploring this thing called the new world of work. And I lead with this because it's kind of cheeky, I think, because for those of us that have been around a while, it's kind of always the new world of work, right? So it's kind of an oxymoron of sorts. And yet I think it's true in this generation's new world of work has some pretty unique characteristics. I spent the last 10 years living in this new world and operating in a self-organizing system called Holacracy. in a way of distributing authority, making decisions, distributing leadership, structuring and getting work done, all without a classic management hierarchy. So I've been kind of living in this space for quite some time. And for me, this new world of work has some very distinct markers. So I kind of want to plant the seeds here, draw a line in the sand. When I talk about the new world of work, I'm thinking of these 5 things and wanting to see these 5 things embedded in how we show up and do our work, start new businesses, invest in new capital structures for those businesses. And the first of the 5 is kind of key. The new world of work is all about purpose. Everything hangs on purpose in the new world of work. We self-organize around purpose. You might think of purpose as being kind of the new boss. If we have a new way of structuring and running an organization, a new way of distributing authority, and a new way of getting work done, we're getting work done in pursuit of purpose. So we want to see purpose embedded in all of our legal structures and management and control structures. So purposeful is the first. Holarchic is just a fancy name for a different type of structure or hierarchy. We're all really accustomed to the maybe 75 or 100-year-old management hierarchy that we've kind of grown used to. Holacracy and Holacracy 1 has done a lot to change our thinking about new ways of getting work done without the traditional management hierarchy. But not making it flat, not getting rid of hierarchy. In fact, that would be exactly the wrong thing to do. It's to implement a different type of hierarchy, a holarchy, which is a natural hierarchy. It's a natural hierarchy of purpose, not of power. So in our conventional management structures, and even our legal structures, we have power held and delegated personally. Top-down, matrices, dotted lines, clever ways of structuring it for sure. But we want a different way of structuring our work and structuring our legal grounding of those entities, of that work. So holarchic is the second. The next is autonomous, the ability to lead unfettered from asking permission in the classic management hierarchy structures or our classic conventional structures where it tends to be more permission seeking. We want a high degree of autonomy, the freedom to lead our work with clarity about what work we are engaged in and within what authorities we have been granted to do that work. So we want a high degree of autonomy. The fourth is a high degree of dynamism. So moving away from what we've kind of grown accustomed to in our conventional system of top-down predict and control, we want to move away from that. And so one of the other markers that we're looking for in this new world of work and in our legal structures is that it encodes dynamism. We sense and respond to what's needed as opposed to predicting and controlling with 5-year plans or 3-year plans. In today's world, new world of work, the complexity, the fast pace of change, that simply is no longer as useful as it once was. And the fifth is a high degree of transparency. In fact, I sometimes chuckle, as much transparency and visibility as you can stomach. And this might agitate or cause folks, the legal folks in the room, to squirm in their seats a little bit, but maybe not. We want a high degree of auditability. We want a high degree of transparency in all of our work, all of our decision making. Even the things that need to be held by statute or regulation or by some other authority held confidential. So it's just navigating the space of visible, transparent, and making even the decisions to withhold information for due and good reason, that make that decision transparent too. So I just want to plant these seeds. You're going to see these recur in a lot of the detail work that we're going to show you here in just a bit. That bakes in these principles that we want in self-organization. the field. And this is not new. Back to my opening statement, the funny thing about the new world of work is it's always new. But yet, we've had some early players. Some of you may recognize the names on the screen here. Lots of folks early on kind of got a sense that our current structures, our current management hierarchy, and better ways to respond to that. And so we've had some early pioneers. Morningstar, folks have probably read about their experimentation with self-organization. The W.R. Gore Company, Valve, and many others have been experimenting with self-organization for a very long time. And self-organization embeds these principles. And so we had some folks that home grew their own structures, their own management structures, and in some cases, their own legal structures. And then Holacracy One, the company, came along. Brian and I launched that company in 2007. And for the last decade, now 2017, that company has iterated and deployed a new rule set, Holacracy, which is a full wholesale replacement for management hierarchy. So one of Holacracy One's contributions to this space was to systematize those principles and that rule set into a portable operating system, a portable management and control system known as Holacracy, so that anyone that wanted to benefit from self-organizing the work could do so, not by reinventing it themselves, but just picking up a rule set that's tried and tested and has now kind of become the gold standard for self-organizing the work. And now we have a whole new set of early pioneers like Zappos and Arca and Springist in the Netherlands and the David Allen Company, those that are now practicing self-organization in a similar way. So we've had a lot of progress. We've made a lot of progress here. But there are still some lingering tensions. Like I said, I've been doing this work for a decade, and I've had the benefit of being out in front and seeing how real people respond to self-organization, real entrepreneurs and some household name entrepreneurs that you might recognize, see how the transformation has impacted their business and their work and their relationship to the work. And the experience has been transformative. I don't think I will ever go back. And I think most folks that experience self-organization and see the benefits and the transformative effects it has won't go back either. And yet, being at this for 10 years, I saw there were still some areas that we haven't quite addressed yet. Some lingering tensions, as I call them. Things around equity, our investment and our capital structures, distribution of profits. What's this notion of ownership now anyway? If we have a self-organizing entity that is pursuing its purpose, who the heck are the owners? And what power do they have? And is that following the self-organizing principles that we care about? And what do we do about compensation related to distribution of profits and culture and leadership and all of this other stuff? It's these lingering tensions that I was feeling while at Holacracy One that led me to think, this self-organization journey has just begun. And we need to continue to push out into new areas, into new boundaries, these principles of self-organization. And so Encode was formed to bring, this is interesting, the slides are kind of, sorry guys. So let me just bounce around here. So I'm going to come back to that. So Encode was formed to build upon this cool work that we've done of differentiating the work. And you guys are probably seeing a lot of slides going back and forth. My apologies. But we'll move forward here. So I will land here. So Encode sensed this opportunity to build upon the work that we did with Holacracy. Holacracy and other systems have begun to differentiate what we think of as an organization from other components that have been conventionally fused. So I go all around the world, and I have the luxury of being in front of a lot of leading thinkers and cutting-edge business folks and entrepreneurs. And I always ask the question, what's your definition of an organization, right? There's lots of definitions of organizations out there. But the classic one that comes up is a collection of passionate, like-minded people all coming together to do really cool work in the world. And that's kind of been our standard status quo, almost de facto definition. And it's the definition that's got us into trouble because it's all fused. That collective of like-minded, passionate people, well, how do you make decisions? And the management hierarchy that we've had is beginning to collapse and not being as an effective tool. So Holacracy and others differentiated the work from the rest and created an organization that was structured to pursue just the work. And to have a clear management control system, a clear set of rules that facilitate self-organization, a clear alignment of your work as your purpose with the purpose of the organization. So we've had a lot of success. But what we've done is we've left behind a couple other systems. So my sense was, and the sense of others, is that we still had two systems that were left behind, the legal system and the people system. So our legal structures and our people structures have not benefited from the self-organizing principles, these principles of the new world of work, that our organizational structure has benefited from. So if you look at this, the legal basis for a for-purpose enterprise, we're differentiating the organization down at the bottom as the work. And then a new container, a container for the legal structures, and a new container for the people structures. So bringing these three together, we have a new type of legal entity, a for-purpose enterprise. And so Encode's work is upgrading the legal structures and the people structures to embed those very same principles into our legal agreements. And so I want to kind of shift into that a bit. Let's take a look here. We have been working over the last year to upgrade some foundational legal agreements. And for the business folks in the room, and especially the lawyers in the room, you'll recognize these. These are kind of confidentiality and IP agreement, an association agreement. The association agreement on the right and the founding member agreement on the left are new offerings that Encode is bringing to the table. The others are pretty conventional fare. It's the foundational agreements that anchor a business entity in a local legal jurisdiction. So I want to dig into these a bit. And I'm going to use our Encode's actual operating agreement and membership grant agreement and founding member agreement to kind of give you a sense of how we're doing this work. But we're not limited to just the States. We've got a lot of folks on the call from all over the world. And we're working with attorneys and companies in a variety of jurisdictions to upgrade the legal structures to embed those principles that I talked about. So we have valid agreements for the states using LLC constructs in the state of Colorado and the state of Nevada. We have an interesting hybrid in Austria with the GmbH Co-KG structure. We have just finished up work in the Netherlands with a BV structure, modifying it to embed these principles. We have a project on the plate working with a law firm and a company in Switzerland to upgrade legal structures there. So this is a global effort from Encode to upgrade our legal structures to embed these self-organizing principles. So what I want to do today is to dig into that a bit, especially with our legal folks on the call. Let me just check in with Yo if there are any questions or confusion about
No, it's just
what Encode is about.
No questions, only tech confusions. We
Only
losing,
tech?
we keep losing you, yeah.
Oh, that's not good.
No.
All right. Okay, so let's look at some of these legal structures. So the thing about starting a company, and I've started several of them. There are probably folks on the call that have either started them or been advisors for those that are entrepreneurs launching companies. And the sad truth is, I talk to a lot of progressive entrepreneurs who have cool ideas and can't wait to self-organize and get everybody involved in expressing that cool idea into the world. And then when they go to incorporating, the choices on the table are all the very same choices that have been on the table for decades. And we have antique legal structures that don't align with our current thinking around organizational structures. And now that we've differentiated the organization from the rest of the enterprise, from the legal and the people, we can now reintegrate from a different perspective and rethink what it even means to start a company. And remember that first principle in the new world of work, purpose. Everything hangs on purpose. So I've been through this process, kind of scoping out partners, individuals that I thought might be compatible with my good idea or getting on board with somebody else's good idea. And we come together and we share our ideas. And then we have the classic partnership dance, right? As an entrepreneur, do you pass my sniff test? Do I pass your sniff test? What are you contributing? And all of a sudden, we're ready to go, and we launch either a BV or an LLC, and we're faced with what all entrepreneurs and partners are faced with. Well, what's our capital structure? Is this a 50-50 deal or a 60-40 deal? And who's going to have the voting rights? And on it goes. The legal structures simply don't reflect the intent to form an entity for purpose. So I wanted to correct this along with the founding members of encode. We've created a new pathway, and we've created a new agreement called the Founding Member Agreement that documents the journey from individuals sensing an opportunity, an evolutionary purpose in the world, and then coming together as a collective, the founding members, to bring that into the world. So we have a new document, a new pathway for entrepreneurs to have a clear chain of authority, a clear line of custody of how you're coming together as individuals, and then ultimately surrendering individual authority into a self-organizing system. So the Founding Member Agreement chronicles that, chronicles the journey of the founding members coming together, recognizing that work might have been done prior to the starting of the company or the organization. One of those markers, we don't want predict and control. We want things to be dynamic. So we have embedded dynamic equity principles in all of our legal structures and capital structures. So we can choose a new way to come to the initial capital table of the company, a dynamic way, instead of predicting or otherwise figuring out what the split should be up front. And then we do a whole lot of other things. We establish lines.
Tom, hang out on for a sec, Tom.
Yes.
You might.
I lost you, Joe. So,
Tom, can you hear me?
You're speaking? I can now.
It's hard to hear you. Are there any programs or tabs you can close on your computer? So this might help for the sound quality of the sound.
Yeah, everything is closed.
Sound is not good. Can you close tabs or programs on your computer you do not need?
Yes, they're closed. Can you hear me?
Okay. Okay. All right. Thanks.
So, can you hear me now?
Yes, thanks, Tom. So just continue.
Great. So the founding member agreement kind of sets the foundation for how individuals come together and sense an evolutionary purpose, an opportunity in the world, to seed that purpose into a self-organizing entity right from the start, so that we aren't faced with having the conventional constructs.
Now we can't hear you, Tom. I can't hear you.
So some folks can hear me fine. Dick says I can hear fine now. Wonderful. Issues with tech.
Yes.
Brianna is good. Travis is good. So I'm going to continue on, assuming that lots of folks can hear okay. So what this document gives us is a way of memorializing the journey that all entrepreneurs take. I've done this many times. Again, as I said, you probably have done this yourself or as attorneys advised others on this journey. And now we have a clear chain of authority, a clear chain of custody, if you will, that documents this journey and sets pre-self-organization. And how do we account for that part of the journey? What happens post-governance? We account for and define that individuals have a purpose too, and they're distinct and separate from the entities or enterprises' purpose. So we actually legally define, to the best we can, what an individual purpose is. And in this case, it means with respect to any natural person, the highest, most primary, and most enlivening, driving creative potential that this person is well suited to express in the world. And we make a distinction between individual purpose and on down the organization or the enterprise's purpose. And remember that conventional definition, that typical definition I gave of organization, a collective of like-minded, passionate people all coming together to do really cool work in the world? We don't want that. As appealing as that might sound, we want something different. We want a construct, an enterprise that is designed to integrate the legal structure, the organizational structure, and the people structures, all for purpose. So we have a new definition of the for-purpose enterprise, that it is the integration of these three things that are coming together to express the current purpose of the enterprise itself. And we define it very clearly and very distinctly what this enterprise is and isn't. That it is an outward expression of that purpose, arising from a self-organizing process, establishing distributed management and control, legal governance, distributed work governance, and on it goes. So we're getting super clear on what this entity is and what it's pursuing and what our individual relationship is to it, even as founders right from the start. So we set the enterprise purpose. It too has something that it's pursuing in the world. And this has been baked into Holacracy for sure. So Holacracy all hangs on organizational purpose, but it is silent on the company. and the founder's purpose, and how that's structured and aligned or may not be aligned with the organization's purpose. So this begins to reconcile the differences here. So on it goes. We have a whole bunch of stuff that we document on the founding member agreement. And the founding member agreement leads us to the first operating agreement. So I want to highlight a few key sections here on how we start to weave together the rule sets into a cohesive whole. So for those of you, and I know a few of you are on the line that are US-based attorneys, and even those that aren't, BVs have these standard sections too, as do GmbHs and co-KGs. And so what we're doing around the world is we're finding flexible starting constructs that allow us to make significant changes to the legal structure while still being valid in the local jurisdiction. So as I said, we have 2 limited liability company operating agreements valid in the US, in the state of Colorado and the state of Nevada, that have embedded these principles that we care about. And I'm going to show you a few of them. So classic preamble stuff, a bunch of definitions, some of which are kind of interesting. So if we scroll down and take a look at, we see repeated the for-purpose enterprise definition in the legal agreement. We see that the founding member agreement is our bridge document to the operating agreement. We see individual purpose coming back. And here's one of the first linkages. So those of you on the call familiar with Holacracy know that it's a rule set. It's a management control system designed to express work in pursuit of the organization's purpose. That rule set has a named construct called a partner. And partners have certain authorities and duties as specified in that legal agreement. And those of you familiar with the LLC structure know that there's something called managers that are authorized to do work and be compensated for that work. So here we begin to weave together 2 rule sets, the legal structure and the organizational structure, into one cohesive whole. And we make managers, as noted in the legal operating agreement, partners, as noted in the Holacracy Constitution. So we tie these things together. This allows us to do some really cool things with membership interests and compensation. Because now we have members of the LLC who are managers. Managers can be paid with securities or membership interests. And managers are partners doing work in the organization. So we can rethink and refactor how we compensate for work, just with these interesting connection points. So partner manager is one. Another big one that we shift is back to something that's been a loophole in most Holacracy adoptions. In fact, most any self-organization, system has a starting point, an initial actor, if you will. And that initial actor must ratify the rule set. And it's usually linked to the purpose of the company, right? And the purpose of the company typically is there to serve the shareholders' interest, making it a for-profit, unless it's a non-for-profit or an NGO or a for-benefit. We want to change all of that too, though. We don't want a for-profit, nor do we want a not-for-profit. We actually want a for-purpose entity. And so here we make a huge leap. We say that the purpose of the company, the purpose of the BV, and this is working now in the Netherlands, the purpose of the GmbH is the purpose of the company itself. So the company has been formed for the purpose, lowercase, to the extent allowed by the local jurisdictions, of executing on the initial organizational context purpose defined by the founding members. So we've linked to the founding member agreement, SEED's initial purpose, and then on an ongoing basis to continue to discover, clarify, and express the deepest creative potential of the organization. And it goes on, taking into account all the capacities and history and talent and partners, And then the last piece is important. So overall, the for-purpose enterprise, with the then currently identified creative potential being the current purpose. So those of you with maybe some good ears and have been in the self-organization field for a while, recognizing here we're encoding evolutionary purpose. And we're saying that this company was founded, was formed to pursue purpose, not to serve shareholders. Shareholders and investment is super important, and we account for that. We just account for it differently. So we're decoupling ownership from investment. We're decoupling purpose from individual preferences. And we're doing this all throughout the document. So this is the deeper dive into the legal structures. So we shift everything to be purpose. And the other big loophole that we close is governance. This is a big one too, equally as big. And again, the lawyers in the room know that this is usually a pretty meaty section of any foundational agreement. So here we usually have boards, voting rights, officers, directors, all sorts of clauses around decision-making and authorities therein. We change that dramatically here. We institute a new governance system, a upgraded governance system, a 21st century governance system. And it's the legal entity itself that adopts it. So this is huge in holacracy adoptions. All holacracy adoptions, and really all self-organizing shifts, happen with some one person or a body, a board, that says, we're going to ratify this new rule set. So an existing power holder says, I personally have the authority to ratify the organization's operating system. So there's a personal power holding still at play. That personal power holder uses her or his authority to ratify the Constitution. That's a loophole. So that person could have a bad day. That person could be ousted by a bigger power holder. And I've seen all of this happen. So there is a loophole where personal power holding can actually get in the way of self-organization. So what we want is to not have that. What we want is the legal entity itself ratifies the rule set. And we do this here. So we specify in Article 3A that the entity itself adopts holacracy. So on the date of the holacracy constitution attached is the sole management and control system of the for-purpose enterprise, informing work governance, work operations, and legal governance. So the Constitution becomes our updated, upgraded management control system. This is big. We gut the rest of decision-making and authority distribution from the legal structure, and we essentially outsource it to a new structure and use the Constitution and that mature rule set and the mature decision-making processes to come to something called due governance, which is down here, that next clause, that everything, all decisions now of the entire entity come to a central integration point. And it's that central integration point where we have due governance to decide how the entity is going to pursue its quest towards purpose. So this is a big deal. Ratifying the Constitution and changing the power structures of the legal agreements, essentially upgrading them and outsourcing them to these new self-organizing management control systems. So on it goes. We specify a whole bunch of stuff. The anchor circle becomes a kind of replacement, if you will, for the board. It is that key integration point. And again, those that know holacracy's constructs know that the anchor circle is the first circle of the entity, and it's the integration point of all the context needed to keep the entity on track, on course. So we do a lot with governance, a lot with authority. We decouple ownership from investment. There are no voting rights in the classic sense. No one can control by owning more stock. In fact, no one technically owns the entity. The entity is pursuing its purpose because it's stated as such. and it's using due governance, which is an integrative process, to figure out how to express that purpose into the world. So one last parting thought here. This document also specifies new capital interest, new capital structures, that everyone, because they're a partner and manager, has the opportunity to hold as an asset, as an investment stake. So we have 4 types of membership units I'll talk just very briefly about, but I do want to bring your attention to one in particular, because it's a new construct that encode.org added that you won't find probably elsewhere in this form. Again, we took the principles of slicing pie, and instead of having it just as a tack-on, an add-on kind of thing that you could read the book, and Mike's got some incredible work, we took that work and we embedded it as another class of membership interest. So those of you familiar with profit interest and deferred interest and capital interest, we created a new unit, a new membership interest called a allocation unit that allows us to track dynamic equity with one of the securities defined in the legal agreement itself. And I think this is huge. So we now have seamlessly embedded dynamic equity into the overall capital structure of the enterprise. Along with the capital interest and the profit interest, we now have dynamic equity interests that can be allocated to any members, managers, and partners through due governance, which means that we can create the right programs, the right policies, the right earnings plans to ratably and appropriately allocate those assets to the members. So I'll take a breath there. I hope you're hearing this. I'm trusting our technology is working,
yes,
but I never know.
Mm-hmm. It's all fine, Tom. Keep going.
Great. Any specific questions about the operating agreement? Some of the things that we're encoding? Notice the principles at play. So those 5 principles: purpose, new structure, holarchic, autonomous, ability to lead, visibility, transparency, dynamic, not static, structures are now baked into the legal operating agreement itself. Okay.
Yes.
All right. So let's look at a couple of the other things that happen. Just real quickly, in most organizations that aren't structured this way, you have employers and you have employees. And this is one of those other aha moments, doing this work over the last 10 years and quite frankly, living in a system without management hierarchy and reaping the benefits of that. And then helping others to replace management hierarchy with something else and successes there. It kind of dawned on me. It was like, we have had great successes replacing management hierarchy. So we don't have bosses. We don't have managers. We're not managing people. This is great. What the heck are we doing with employees? What's that about, right? So in a conventional structure, you've got all sorts of limits that a legal entity can have employees, and then there are labor laws at play in a variety of jurisdictions trying to protect the employee from the employer, and it's a crazy setup, right? And it's worked okay for, I guess, till now, but I think this is another marker of the new world of work. There must be a better way, and I think there is, and we're starting to get some.
Tom, there's a good question in the chat. I will read it out. How is it that no one owns the entity? Where was that decoupled?
So everyone has an investment stake. So everyone in the conventional sense will have a certain number of capital interest. And the certain number of capital interest will, of course, foot to a percent of the overall holdings of the company, of the legal entity. So in that regard, it's the same. You still have an investment stake, and some investment stakes are capital interest stakes. But what you don't have are voting rights. So you don't have the ability to trump or outvote. you've agreed to play by a self-organizing, distributed authority rule set, where your perspectives as an investor are integrated along with everything else needed to keep the whole enterprise on track. So you're still a capital investor. You could even be the 100% capital investor, quote, holding the entirety of the capital assets, the capital interests of the entity. But that does not give you the right to outvote any decision. So this is the decoupling of ownership with implicit authority held personally as owner with investment who has a right and an expectation to get her or his investment perspectives integrated into the overall system, but no right to trump or outvote. Hopefully that answers a little bit of the question.
There's another comment, Tom. All great. However, whatever we write in legal company constitution cannot override law, like Companies Act in the UK, which give directors responsibilities in law.
Yes, absolutely true. So what we're looking for are ways of reconciling with current jurisdictional or code requirements. So we're looking to pick the most flexible form. And in the UK, limited by shares comes up a lot. So that's one. We haven't been through this process. In the Netherlands, the BV, what we found, was flexible enough to encode these principles. But you're absolutely right. We do have to align with local laws, for sure. This is not trying to skirt them. It's trying to push as far as we can. And in the States, because it's a hybrid partnership, corporate partnership structure, we can fully embed and embody all of these principles. There are some limits, though, and we're in an ongoing effort to find better forms all over the world. So the GmbH Co-KG structure has some limits, and we've mitigated those risks or those restrictions to the extent possible. So it's a great question, probably a little bit deeper than we can get into in our webinar, but we're finding ways of pushing those boundaries to the extent possible and calling everything out, making any implicit personal power holding diminished to the amount allowable by law.
There's another question. Should we pick on that now? Why I read it out to you. As an investor, can I threaten to take my money out in case certain decisions are or are not taken?
No. So the operating agreement encodes the investments in such a way that you can't personally decide to pull your money off the table because it's an investment in purpose. You become a purpose investor. Now, you have remedies and means to convert your investment to dividends or appreciation rights to sell. So you can do all of those things, but you don't get to wield your power personally. You don't get to pull your chips off the table and claim, I'm going to take my goodies and go home, because you've agreed to a different construct up front. And these operating agreements spell out clearly the treatment of each of these membership units and what rights come with them. So it changes that dramatically. In fact, we've had lots of conversations with VCs and social venture capital looking for good pathways to deploy purpose capital for purpose investments. And this is a structure that would allow for that. And it changes the game of venture capital, seed money, angel investors, Series A, all of that changes. Dynamic equity principles at play. This is the juicier stuff for sure. I'm just showing you some of the mechanics of the legal agreement so you can get a sense of what we're about. But the real fun stuff is what this allows us to express and change.
And there's a subsequent question. So how is that enforced, Tom, that an investor cannot take money out? So we haven't had that case yet.
By contract. And so I've got my legal muscle here. Yo can probably answer that question, or any of the other attorneys. So it's by legal contract. The agreement is in place amongst and between the members to play by these. And if there's a dispute, that's not to say that there could not be investor disputes. There always are. Humans are involved. We have language in the document to mitigate that risk to the extent possible. And then at some point, the courts will get involved. And that's where it will get really interesting, when we start setting precedent around these kind of constructs. And we aren't there. but I'm ready to start pushing those edges too, consciously, sanely, but find out where those boundaries are and push those limits. And you know what? This is up to. This is not an encode thing, democracy thing, or a niche. This is global. This whole self-organization, the independent worker, the gig economy, the peer-to-peer nature. In the US, there's legislation looking at, you know what, our contractor designation doesn't really work. Part-time, full-time employees don't often work. There's some initiative to try to create a new class of employee. I think they missed the mark there, but the point is, this is up for lots of folks across different practices and disciplines of figuring out what's up with this new world of work and how do we encode it legally. And Encode's contribution to that is to create legitimate legal structures to enact these principles and start doing real work and test the system. All right, so let's see. I'm going to take you through just a few more of the agreements. We won't stop long on this one. It's pretty straightforward, but it's the replacement for the employment contract. We don't have those. So we have no employees in a for-purpose enterprise, self-organizing to pursue and express purpose. We have all legal members. So instead of an employment agreement, you have a membership grant agreement. And this is a lightweight document, relatively lightweight. It only has a couple things that we're focused on. It's an agreement between the member and the organization, the enterprise. And it identifies the member as a partner and role filler. We've talked a little bit about that. And it sets something interesting here, focus time. So because we don't have employees and we're not bound by labor laws, we aren't bound by the same litmus tests that employees are measured about qualified, non-qualified, part-time, full-time. So we have the opportunity to align more naturally with an individual's orientation to helping the enterprise express its work. And this is something that we call focus time. So the member gets to elect how much energy do they have to contribute to a purpose greater than themselves. And we can set a focus time, which is a % of her or his total productive capacity to serve his or her individual purpose or pursue other endeavors of that total capacity that you have as an individual, an agent of purpose in the world. You're going to select a certain portion of that and allocate it to this other purpose and make it explicit that you're going to show up and allocate 20% or 40% of your energy towards expressing this entity's purpose. We can have a lot more conversation on how that gets broken down. The other is this initial grant. So we've defined membership interest. One of them is a profit interest. And it allows us to have a substitute for what everybody wants in the world is money in their bank account for good work performed. So we do that by issuing everyone that's a member, whether you're right out of school just doing administrative work or support work, or a 30-year entrepreneur doing creative leading edge thought work. Everyone gets a P unit grant or a profit interest grant. And those of you familiar with the profit interest structure know that that gives you a right to certain profits of the company under certain conditions. And so we write an earnings program that translates all of that into a requisite or adequate comp plan for individuals. So everybody selects a focus time when they come on board, a for-purpose enterprise, and they get an initial profit interest grant. And that's the extent of it. There's a lot of moving parts for sure, and business is complex, and these agreements are complex. But from the end user's perspective, you find a purpose that you care about. Yo has come to, she's an attorney in Hamburg, a mediator, she's bringing decades of experience, and she is lit up. I don't want to put words in your mouth, you can speak for yourself, but she has a little bit of time and a lot of interest in expressing another purpose into the world. And she can come together, sign a membership grant agreement, allocate a certain portion of her time, be compensated in a certain amount of profit interest. And that's it. then it's work. Then it's working with other people, doing the stuff we love, all the complexity fades to the back. So we have a replacement for the employment agreement, and it's called the membership grant agreement. Just a couple others before we bring the agreement sections to a close. We have confidentiality and IP. This is another classic document. We rethink this a little bit because, as I said, we are all independent agents. We want to encode that autonomy thing, right? So Yo has lots of interests, as do I. And I think as do many people in the world now, especially younger generation is looking at lots of opportunity. And they don't want to be boxed in by one employer-employee construct and prevented from exploring lots of different opportunities or serially moving from one employer to another because it's a binary kind of thing. And then there's all these antique agreements like non-competes and confidentiality agreements. Not to say that those are unimportant. I get the importance of a 30-some-year entrepreneur. I get it completely. But we need to rethink it. We need to bring dynamic principles to figuring out how to steer these competing interests around confidentiality and having multiple interests. And so Encode has done that. We have places in the operating agreement that have shifted to allow us to do something new with the confidentiality and IP agreements. Like, and I won't go through the whole document here, but I've highlighted one section. So a partner, that's a member of the organization, may use or disclose confidential information in connection with other outside businesses or professional activities if the partner determines in good faith that the proposed use or disclosure would not reasonably or foreseeably or harm the company. And a whole bunch of other stuff, for sure. And if there is a conflict, remediation, we fall back to due governance. In other words, we dynamically steer this. Sometimes it makes great sense for an individual to use their capacities and share them with others because we have common purposes that are aligned. And it is reasonable to do that without having to seek permission, the freedom to act autonomously and use good judgment. To the extent that works, and I think oftentimes it will, and I think historically it's how most of the relationships actually get structured. That's a goodness. That's a good thing, I should say. It's lightweight and gives people freedom to act towards purpose. When things go sideways or there's a different perspective at play, and that certainly happens too, let's rely on a 21st century decision-making process to integrate differing perspectives through something called due governance that I mentioned before, that's baked in and threaded through our entire legal structure so that we can come to some workable way forward, integrating the needs and the perspectives of the various parties at play. So we upgrade this too, to use a new tool. We rely again on Holacracy's integrated decision-making process and the notion of due governance that we encode in the operating agreement to rethink how we deal with intellectual property and confidentiality. And I think this is really cool because this gives individuals the freedom to show up again as these agents, not employees, but as these agents of purpose, engage with lots of for-purpose enterprises, many, well, there's a limit, I'm sure. But I'm currently engaged with 3 for-purpose enterprises, and it allows me to navigate these spaces with clarity and still gives the entity the right to protect its intellectual property and work product. Because, hey, guess what? I'm also an investor. I do care that our work product is protected. I do care that we're building ongoing value in the enterprise as an investor. It's fascinating how it shifts all of that. And it just changes your perspective. And it gives you more lines of perspectives to integrate as you're making your own decisions on what's good for the purpose and what's good for me. So that's the membership grant agreement. The very last one that I will just show but not speak too much on
there are some
because
questions.
It's not our focus here. Our focus for this webinar was the legal containers, the company structures, and the legal anchoring. So we upgrade the legal structures to be compatible with our organizational structures. But the other system that I said was left behind were the people structures.
Hang on, Tom, before you do so. There are two
Yep.
questions. Can you mute yourself while I speak? Tom?
Yes.
Yeah. Ra told me this is important. Okay. So the first question is by Sue. Does focus time need to be sole focus, or can it be time that is used for two different purposes for two different organizations? And then further specified by Sue, what if someone works 80 hours a week? Can I have 100% focus on one entity and 100% focus on another?
No.
And no, yeah, no, you cannot.
Well, not for long. So there are limits. And focus time still has something that's unwanted, is this whole notion of time. It's really about the orientation and the contribution you're making towards the purpose. And so it doesn't have to add up to 100%. And it's not necessarily based on the classic 40-hour work week or 36-hour work week. It is different than that. And we could dig into that. That might be an interesting separate topic. But the notion of focus time doesn't have to foot to 100%, is the short answer to that question.
I think this should be probably further discussed in another context. But a question by Christoph is, will split of profits as whatever units be made according to spent focus time? A complex one.
Yes. So a good earnings plan should be crafted to account for individuals' time commitment, energy commitment, and then pro rata adjusted accordingly. So in this system, it's really kind of interesting. You can rethink compensation completely and create earnings programs that deploy profit interests. And those profit interests scale depending on how much focus time an individual consciously chooses to bring. And that focus time could be variable. So you might have 100% and then drop to a lesser percent and then back again over a year or two. So you have a lot of variability, back to that dynamic principle at play. And the earnings should adjust ratably.
Okay, now to association context.
All right. So I don't hear you at all, Yo, but I can see you. So I will go ahead and just kind of close out this agreement and then pop back to our slide presentation to close out the detail. So this other container. So remember I opened with, we wanted to upgrade the two systems left behind. We had a lot of experience and success in self-organizing the work. We left behind the legal and the company structures, company as we call them. And we also left behind the people structures. Now in this new enterprise, where everything is for purpose and we no longer need employees, what do we do with us people? Who are we? How do we relate with one another? What are our behavior norms at play, the cultural norms? How do we interact and mentor and mentee one another? So the third context, if you will, the third aspect of the for-purpose enterprise is a container of the people, an association of like-purposed, not necessarily like-minded. In fact, like-minded, we don't want. We want diverse perspectives. We want a diversity of perspectives at play, all in pursuit of purpose, common purpose. So we create a container called the association that has a rule set too. So one of the things that Encode is bringing to the table are clear rule sets, written down structures, not aspirational kind of things. So we have an agreement of the association that encodes what's the relationship between and amongst the individuals, the individual agents of purpose, these members that aren't employees. And so that could be a separate webinar for sure on what goes on and how that's structured. But there is a third agreement, or not third, well, another agreement for this container, documenting the agreement amongst and between the members of the association. So that rounds out the deeper dive into the legal agreements and structures that allow us to upgrade the company and the association. I'm going to bounce back now to our slides and just kind of round this out for folks. And then we'll open it up for Q&A. So we started with the founding member agreement, kind of the chronicling the history of us entrepreneurs as individuals, coming up with a good idea or an evolutionary purpose, if you will, and seeding that purpose into an operating agreement that is entirely for purpose, granting members access to that through a membership grant agreement, rethinking confidentiality and IP, and then encoding this collection of people. I hinted at this, but I just wanted to call out that Encode has created these new capital structures that allow us a lot of flexibility to rethink how to capitalize, grow, and scale an enterprise. From the very first forming moments when a company is first formed, delaying the capital structure decisions through dynamic equity, all the way through potentially taking additional rounds of investment capital, and then navigating the ebbs and flows of profits and revenues and income, and then using these new instruments to account for long-term investments in purpose, long-term capital interest, shorter-term profit interests, so that people can be paid for their contribution and their work, and accounting for any deferred interest, so profits earned but not yet taken, and then the dynamic allocation interests. So these, in simple terms, are 4 types of membership units: C units, E units, D units, and A units that are delineated and defined as part of the operating agreement. They're essentially securities in the enterprise. So just to kind of bring the picture together here, our webinar was about legal governance. Our focus was about the legal structures and the weaving together of these 3 containers into a for-purpose enterprise. We have the organization with its rule set, the Holacracy Constitution. We have a company with its rule set, depending on where you are in the world. It could be any kinds and varieties. And then we have the association, which is the collective of people that are coming together for a purpose. And the legal operating agreement ties these all together. So on the company side, we are looking at the management and control in legal terms of the organs, as it's sometimes referred to, giving rise to the legal company itself. We're tying that together and relating it to the organization, which is another type of management control, but now of the work, and a governance system to control and express that work in pursuit of purpose. So the legal governance is all tied together, tying the organization and the company. We get asked all the time, especially with my history with Holacracy, is Holacracy the only management control system that you're playing with? And it's a short answer is yes for now, but I think there will be other rule sets down the road. And it would be interesting to plug and play, if you will, those rule sets into new legal structures. And I think the criteria, we've come up with 3. So in order to make this work, in order to even contemplate upgrading the legal structures the way we're doing, we need a mature, robust, tested management control system. One that has, number 1, a clearly written down rule set, that number 2, binds everyone. No one is above the law. In fact, I kind of loosely equate that with it becomes a wholesale replacement for the management hierarchy. And 3, no power being held personally. As soon as we have power held personally in that system, everything breaks down because we can't trust those individuals as much as we may want to or like to act within the rule set of a valid control set that would allow us to upgrade the legal and the people legal company. We're outsourcing it to the Holacracy Constitution and embedding it in a structure called the anchor circle. So that brings us to opportunity to dig in. We have about 10, 15 minutes for specific questions, and I'd be happy to answer them, or Yo would be happy to answer them. So I know I've been talking a lot. We don't have a bidirectional audio, so I couldn't hear you guys, and I understand that there might have been some problems hearing me, so apologies for that. But I will see if there are any questions out there. Yo?
Not for now, but perhaps you can have a look into the chat too, because Ra told me that when I speak and you are not muted, that it's tough for the participants. One open question really is by Timo, but he has to leave now. He says, in Switzerland we have a concept of Scheinselbstständigkeit, as if, yeah, employment, and you're not employed, but you basically only work for one or two employers. So we have to bear this in mind in whatever we do, really. And we have that too in Germany, yeah.
Yeah, absolutely. So we are working with local attorneys with expertise in these local jurisdictions to navigate this space. So folks on the call, if you're interested in this, this would be one of my asks of you. If you are interested in this, we are curating. In fact, Yo has the role to curate a community of practice around law to address these issues, to find out where the new holes are, where the new gaps are, where the new constraints are, and how do we integrate those to the best of our ability. So we're searching for good, flexible legal structures as a starting point. In Switzerland, the one that has our attention right now is the worker cooperative, which is pretty robust and very mature in the Swiss market. And there are others that we're looking at too. We have interest in the Ukraine, actually, recently. We have interest in Argentina, in Latin America. So this is a global effort, and we're looking to curate a community of practice around law with these topics.
Yeah. Isabel from Spain writes that the right structure in Spain could be cooperative. This is more a comment. And Kelly from the US, she asks, have actual operating agreements been filed in Nevada and Colorado that follow these documents? And can you tell us for what companies?
Yes, so we have companies operating in Colorado with a valid Colorado LLC, and we have companies operating in Nevada with a valid Nevada LLC that essentially has these principles embedded. In fact, Encode, of course, is one of those. We decided to use Nevada as the most flexible vehicle. Encode.org is a Nevada LLC, but we would think of it as a Nevada FPE, a for-purpose enterprise. Mm-hmm. Now, the next round would be get the local states to actually recognize that, maybe. But that's not a fight that we want right now.
Andrew asks, hi Andrew, what are the liquidation mechanisms and the order of operations for the various equity units?
Yeah, great question. So there is a shutdown mode, of course. So through due governance, you can decide to call it quits and liquidate, of course. And then there's a schedule of what takes precedence, and it's the usual, going from profit interest to deferred interest to capital interest, and then any creditors, all of that kind of stuff. So there's bankruptcy or insolvency or conscious shutting down the enterprise. Those rules are encoded in the operating agreement.
Andrew is writing a reply.
Okay.
Okay, let's see. One question was, can all this be applied to any enterprise type? And we already answered that we are looking for the right and suitable enterprise type in each jurisdiction worldwide, really, Christoph.
Yep, that's exactly right.
Okay, I don't see any more questions. Are there? Yeah, Kelly, does the new entity formation as a benefit corporation help?
It's different. So, like I said, what we're creating is not a for-profit or a not-for-profit or an NGO or even a for-benefit. So it's a different structure. The interesting thing, I think, is that you could encode this platform is flexible enough that if you wanted to encode the for-benefit, the B Corp values, you could absolutely do so through due governance. This is one of the beauties of being all about purpose and integrating the needs and the tensions across a vast variety of enterprises and people and preferences. So we have a very robust mechanism to integrate the needs and preferences at play to keep the whole thing on course. So, for Kelly's question, if this collective and this enterprise doing this particular kind of work, pursuing this particular kind of purpose, felt that it was beneficial to encode B Corp values, then by all means do so. And you have a vehicle and a mechanism to encode it and then keep it evolutionarily fresh. So you're not hard coding anything. This is one of the beauties for all the developers and software folks in the room. You don't want to hard code to the extent you can, because this violates one of those 5 principles: predicting and controlling, hard coding something in. To the extent possible, you want it to be dynamic, to be able to sense and respond to what's needed, and through due governance, due process, dynamically steer.
Perfect. Kim tells us Florida has a social purpose corporation. I think it overlaps the B Corps. It may be an entity formation that is friendly for this.
Lovely.
That's a comment.
I would love to learn more.
Then Andrew has another question. How are resources optimally managed to promote purpose rather than profit?
So profit is simply a measure in any system, really. It gets mistaken sometimes for purpose, but really never is. So that integration point that I hinted at, the anchor circle, guess what it does? It integrates the 3 things that any entity needs to express purpose. So the anchor circle integrates the assets, the capital structures, including profits, the organization, the operations and expression of work in pursuit of purpose, and the partners, the people, the talent, the energy needed to do that work. So we have a circle in holacracy language that serves as the anchor point to integrate those perspectives. And again, through due governance, we dynamically steer the competing needs and priorities to keep us on track. Sometimes you take less profits out of the system and keep more profits in the system for growth and scale. Sometimes you do exactly the opposite of that. But we now have a system that can sense into dynamically what's needed and respond through due governance to get clarity on how to.
Great. Dick has a comment. B Corp is for profit and codes for purpose, but not shareholder power as described here.
Yeah, that's one of the things. There's some really innovative work, especially in Europe, around purpose ventures, purpose capital, dealing with that sticky issue of the states or the legislative bodies want to hold one person accountable. So there's, I think it's Purpose Capital are the folks experimenting with the golden share notion. And there's a lot of folks wrestling with this about decoupling power and purpose, decoupling ownership and investment. And so we are certainly doing that. And we're trying to push as far as we can legally push to encode for purpose and still account for investor needs, but not let investors show up as owners to trump or privilege. And as Dick points out, a lot of the even progressive systems still have not upgraded their foundational legal structures to address that problem. And I do consider it a problem.
And Michael asked, are there any materials that I can take to partners that I'm exploring in setting up an organization? So I guess, Michael, you're referring to any legal docs?
Yep. So we're still getting our feet under us a bit. The documents I was showing you are version 2.0 documents. As soon as that work is complete, we intend to open source and make these templates available for others to model or use. So we want to see more of these for-purpose entities in the world. And we intend to share our legal documents to make that happen. The thing about that is, as you've just seen in a 90-minute webinar, these are still dense and complex. So we are also working to make them simpler. And something that we didn't address in this webinar is to encode them in software. So we have a whole part of our business to make these agreements in some way smart, hold them in software to take some of the complexity out. We just aren't there yet, but that work is ongoing. So the short answer to Mike's question, soon you'll be able to have these templates better to engage with us, not commercially, but just to explore what's possible. We do one-day workshops, and we try to make this as visible as possible. And then there'll be other tools and support materials coming later.
Okay, any more questions? We've got 6 or 5 minutes left. Isabel from Spain. Hi, Isabel. Please let me know if I can help to make it viable in Spain. We will let you know, Isabel, for sure.
Yes.
Isabel and I met 2 days ago in Madrid. Great.
Wonderful.
So if you do not have comments or there are questions, please feel free also to write a closing remark to us about the webinar, about the work, about going together, to the future. But there are more questions. Malek, are you considering to use blockchain for encode in software?
Yes.
Yes, we
sure
have been. Yes, yeah. Christoph, I have to leave. Thanks for the webinar. Oh yeah, ciao. Ciao, Christoph. So please also feel free to give feedback or comments on our work, on the webinar, and happy to stay in touch. Kelly, thanks.
All right, thank you all very much. It was a pleasure sharing this with you. Take care. Hope to see you soon.
Yeah, okay. So thanks. Bye to everyone. Perfect. Hi, Laurie. Okay. Thank you all. Okay. Good. Shall we go backstage?